You generally go to the bar one.
No, we're going to work, sorry.
Can I ask you a question?
Yes, of course you may.
About contracts then, and the concept of codes, which the new civil code has been trying to write out of French law, but we still have it in Guernsey.
And still in Jersey.
And Jersey too.
But the thing is that whereas you can look to the Code Civil for developments of customary law, when you have a long-standing concept there, when you're talking about one of the core concepts within the Guernsey law contract, and they're making a legislative change, you can't see that legislative change as being a continuation of the pre-existing law. So it would be almost more natural if you were to be developing codes to turn it into consideration. Although if you actually look at English common law contract cases, it's very, very rare for a court not to be able to find consideration. But codes is obviously something often vaguer and more moral than consideration, and that's how it's progressed, that's how it is. And it's difficult to see how you change that without codifying it. I mean, it's possible for codes to become so broad that as to become meaningless. It's possible, theoretically, over the years to discover that actually it's come to mean the same as consideration. But that's a big leap. But to leap to whatever the French have done in their code, and that's a different matter entirely. It's a bit like it's difficult in much of the, even if Jersey had continued to look to the Code Civil in terms of tort and negligence, in many parts of the law of negligence, including that substantive liability, that would be very difficult now, because I think they've moved away from fault-based liability. So if you make a fundamental change from that, like that, then they've made it a policy choice to go in that direction, and you don't necessarily follow them in such a fundamental policy choice. Yeah. So, for example, I have absolutely no sense of trying to push things too far or ridiculously or unprincipledly in trying to introduce PPOs, for example, into Jersey customary law. That's something which may or may not be accepted by the courts. What would be a ridiculous step would be to try and by judicial interpretation to adopt a New Zealand system of no fault payments, because it actually requires a massive social superstructure to support their new concept of, I don't even know if tort is the correct way to describe it, but they've moved much more to a way of an approach of social insurance. That's not something that can be done by judicial decision. And I imagine. So it comes back to the idea that you can't, the Code Civil is more relevant where it's on a continuum with pre-existing law, or law which you can actually show has been assimilated into Guernsey law. When it makes leaps of policy away from that, then as the Code Civil is a legislative act, it's really for the legislature to follow it, or not. Does that make sense? Yeah. Okay, now, the courts of the bailiwick, they should not take long It's basically all in the study guide, and this is now getting to more technical part of what you might be asked. So if we had like a pop quiz section, this would lend itself to it quite nicely. Questions about the courts could easily be written into a question about legal sources, because we now come again to what we were talking about before in terms of precedent at the different levels of court. So the Royal Court of Guernsey is the court of original jurisdiction. What does that mean? It means if there is no other tribunal that has been created to deal with an issue, it deals with the law. Any issue of law, the default court is the Royal Court of Guernsey. It doesn't have to look to statute to give it authority over the law, although statutes will often prescribe how it's involved, particularly if it's on an appeal from a tribunal. Appeals as regards decisions of government are often either to tribunals, or there might be an appeal from the decision of the minister to the royal court. Full court, judge and 7 juries, ordinary court, 3 to 6 jurats. I mean, you don't have the situation in Jersey where the default royal court is actually just what they call the inferior number, which is the bailiff and 2 jurats, which, given that the jurats are the judges of fact, leads to the obvious issue that they can easily be tied in their votes, in which case the bailiff gets a casting vote even though he's not otherwise a judge of fact, which is a bit of an odd position to create, but there you have it. But anyway, perhaps the interesting things are that the Royal Court of Guernsey is also a court of Alderney and Sark. And that's interesting because Alderney and Sark are separate national territories as well. So when, and in this case fortunately Gordon's not here, when the Barclay brothers, in their interminable litigation, for which I won't say anything else, which turn up and say, our so-and-so should be entitled to vote in Sark because this is a local legislature, and under European law he's a Slovakian and he should be entitled to vote in Sark, to which the answer was no, Sark's government is a national government. But despite this, there's also the concept of the bailiwick of Guernsey. So there are matters which can only be heard at the Royal Court of the bailiwick. Criminal matters, historically, have been largely judged in the Royal Court of Guernsey. It is also the first appellate court from Alderney and Sark, meaning that you have many more courts to go through before you reach the Privy Council, which makes it quite amazing how much often these cases come from Sark. The Guernsey Court of Appeal is a statutory court. In fact, the Court of Appeal in England and Wales is also a statutory court. Certainly the criminal court. I think both of them are actually. So its power is entirely the creation of statute. It was created in 1961. Originally heard very few cases. I think there were only up to 9 civil cases with Smith and Harvey in 1981. Since then it's become much more common. The bailiffs of Jersey and Guernsey are ex officio members. Plus you have leading lawyers and also ex-judges who are at a loose end quite like to join these courts. Previous judges, Hoffman, Sumption, Clyde, all notable law lords or Supreme Court judges. Jurisdiction can be excluded by statute, although only done to date in Jersey. Have you got an Extradition Act yet? How's that getting on? When you get an extradition, when you get the Extradition Act, it will exclude the jurisdiction of the Guernsey Court of Appeal, because that's the model for the Extradition Act in England and Wales, to try and keep the appeals limited. And we did it in another statute. We did it without even asking for permission from the Ministry of Justice. We just did it by regulations. So the ultimate court is the Judicial Committee of the Privy Council. Now, on one view, this is not a court, but if you look at its website, it is, and it has very much taken on the nature of a court. If you read the 19th century decisions of the Privy Council regarding the constitutional issues in Jersey and Guernsey, it doesn't read quite like a court. It reads a little bit more like an advisory council. And when you start taking the view that actually, whatever might be the legal position, I think this order in council should be done away with because it's against convention. They're actually not really, in those cases, behaving like a court, because historically this is the royal power over justice being exercised outside of the United Kingdom. So this is very much your appeal to Caesar is the historic root of it, and the Judicial Committee of the Privy Council was established in 1833 to essentially systematise that, so that instead of it being in any way an appeal to Caesar, it was to be dealt with properly by lawyers and judges that could be relied upon. So timeline was that this was the final court of appeal for a quarter or more of the world's population. Nowadays, it's the residual parts of the British Empire, the overseas territories, plus the Crown dependencies, plus a small number of countries that have retained the appeal because they feel it's just useful. If you're Mauritius, for example, you have a population of just over 1 million. You're a small island that has nothing particularly in common with any of its neighbours. And it's quite good because for rule of law purposes to have this appeal. The Brunei retains the appeal to the Privy Council. Much of the Caribbean retains the appeal, although they have abolished it in part for criminal cases, because essentially you won't get British judges upholding a death penalty, and they still have the death penalty in much of the Caribbean. Low hurdle for money cases from Guernsey, A versus R. Now, Guernsey does not have a time limit for bringing an appeal, but here delay may count as abuse of process barring the right. Essentially, there's been an attempt by the Guernsey courts to introduce the idea of abuse of process to create sort of regular procedural bars to appealing to the Privy Council. But those couldn't work as regards the size of the case, but the importance of the case, but could work as regards abuse of process matters. Judges are effectively the same as the UK Supreme Court. So that's why if you have a Supreme Court case which says no, we're not following a Guernsey Privy Council case, even though it's exactly the same sort of area, and there's no way of distinguishing the two, you can reliably say that if you were to rock up in the Privy Council the next day, they'll be following the UK Supreme Court rather than any older Guernsey Privy Council case. Royal Court sitting in chief, please. This is very much, if you have a pop quiz, you could just about have 1 point on this. It doesn't have any judicial functions, but its main importance for you is that it admits newly qualified students to the Guernsey Bar. I don't think you have a big ceremony, do you? Because we have to deliver. We have to deliver a speech.
Yeah, the proctor gives a speech.
Oh no, no, no. You.
No,
We.
the
Oh, no, the advocates.
There is some kind of ceremonial kind of passing them. But isn't
No,
there?
we all have to deliver our first address.
There's a full court tomorrow, witnessing your advocates. Tomorrow morning.
But
There's
that's
a
not
story,
true. But that's
there's a
not true.
story about somebody giving like a 40-minute speech, so they just did away with it quietly.
Oh. Well, the main thing that people remember, people remember the recent guy who did an anecdote which seemed to involve him getting drunk and sweating a lot in the Cayman Islands, and no one knows how it ended because they were just all bored. And you can't look at this guy now without just, and unfortunately it's a really memorable face, and you can't look at him without just thinking, you did that really bad speech, didn't you? But there's one of the practicing counsel, is that Olaf, I can't remember his surname, but Olaf did a magic trick at his speech. He is in fact a semi-professional magician, and apparently really, really good. But it was thought that was a bit bad. I considered doing the Rubik's Cube in my speech, but I realised I can do the Rubik's Cube, but I can't do it and talk at the same time. So I thought I'd better drop that idea. It was going to just end in a disaster.
Is there a guideline how long you're allowed to speak for?
You're meant to speak for about 5 minutes. If you're interesting, you can speak for longer because people won't notice. If you're boring, you'll notice. Other courts and tribunals, the magistrates' court. I mean, I'm sure. Is there going to be a civil procedure paper or procedure? This is much more really for that. Magistrates' court, contracts court, passing land, contentious goes to the royal court. Ecclesiastical court, worth noting at the moment, because I understand its wills and states function. I understand is going to go to the royal court.
It goes to royal court if it becomes contentious, but the general
But
stays with them.
But because historically, and it was true in England and Wales as well, certain functions were held by the church. So wills were held by the church, marriages was a matter for the church. If you wanted a divorce before 1856, I think you had to get it either ecclesiastically, which is impossible, or you had to get an Act of Parliament. So the non-religious functions are likely, I understand, to be transferred to a more secular court soon, but that's for no better reason than people just like to modernise for the sake of modernising, which in the past you rejected in Guernsey, but unfortunately you're succumbing to that sort of idea. And statutory tribunals for specialist jurisdiction. The important thing there is that when you create because I know that in part the course includes a lot more administrative law than the Jersey equivalent. The important thing is that if you create a specialist tribunal, it ousts the ordinary jurisdiction of the royal court. So if you have a right of appeal to the Guernsey Tax Tribunal or Social Security Tribunal, you can't re-argue the issue in front of the royal court. The only appeal you have is the appeal that actual statutory process allows for to the royal court, which is would usually be won on a point of law. So always remember, the purpose of the tribunal, usually, is to find the facts, so concentrate on finding the facts. Don't worry about how much they muppet up the law. Now you have two other courts to deal with. There's the ordinary court, and of course when you start talking about the ordinary court and the Sark court, these are tiny jurisdictions. Ordinary, I believe, is down to its last census it was down to 2,100 people. It's like a drop of 12%. And I think only 1,100 of those had actually been in ordinary at the time of the previous census. So that's not just a drop in population, but a massive turnover of population. So ordinary has 7 jurors. One of them is the chairman, a legally qualified clerk. So to me, it's looking almost like the magistrates' court in the UK. It has unlimited jurisdiction in civil cases. A special, more professional judge can be appointed by the bailiff if required. so that it can then take on much more the trappings of the royal court. Its criminal jurisdiction is limited. Essentially minor offences go before it. Greater offences will have to go to the Royal Court here in Guernsey, and the appeals are upwards. Royal Court of Guernsey, Court of Appeal, Privy Council, and trundle its way up. Court of Seneschal of Sark, again we're missing Gordon for this. It's the sole court of justice in Sark, but it's not the only Sark court or court with jurisdiction over Sark, or original jurisdiction over Sark, because the Royal Court of Guernsey does as well in criminal matters. And that's what it said in A versus R. It does not exclude the possibility of legislation essentially kicking things up to the Royal Court of Guernsey. Now, imposes 1 month of jail or fines £5,000. Obviously, I imagine jail is not served in the Sark jail. Have you all seen the Sark jail? It'd be like locking somebody in a cupboard for
Yeah, the smallest jail in the world, I think.
Isn't that the one in Herm?
Oh, was that her?
Is that Herm? Herm's got a jail.
Is that by the White House?
It's in front of the White House, yeah.
I think,
Just like a
Does
van.
anyone actually live on Herm? I mean, is it just...
Yeah, I did
There's a
once.
school there.
Is it just her to...
Well, they've got about, my sister-in-law was an island resident there, so they have about 20 or 30 island residents that are usually taken up by the general manager, the people that they need who are not seasonal staff, effectively, and so they live there permanently, and they've got staff accommodation.
So you can't just buy a house on Herm? Pity.
Well, you could lease it though, presumably, from the family unless the lease on...
It's not a family now, it's a charity that owns it, but you couldn't lease it from the family when the Wood family owned it. They just had a
So Sark it is then. So the Court of Seneschal of Sark, Seneschal is appointed by an appointments committee. Obviously, great deal of sensitivity around creating independence of the judiciary within an island that is so small that everybody quite literally knows each other, which people tend to say that figuratively about small islands like Guernsey and Jersey. It isn't really true of them, but it certainly is true of Sark. Appointment 5 years renewable. Now you can have, under the European Convention, obviously has a problem with judicial appointments which are precarious, but 5 years renewable is perfectly acceptable and perfectly standard in many jurisdictions, even though it's not what we're used to in England and other parts of the common law world, and of course America, where you get them for life. Don't you?
In some of the more enlightened jurisdictions.
Yeah, and some of them just elect them, and then the deputy seneschal could be appointed, and once again you have the idea that if you need somebody who's legally qualified, then somebody can be appointed. That's like a special ad hoc judge. And again, there's no problem in the convention with appointing somebody for a single case. It's far better to appoint somebody for a single case than for 6 months or for a short renewable period with someone who flies in because you need somebody from outside. That's an entirely different matter. Right, now we have European law. And this will be the last topic, and we have 45 minutes to deal with European law. And I should say that if you were in Jersey, you would get Alistair Sutton dealing with it. And Alistair Sutton is the most learned person in European law. Could you just do these?